let's talk about the exclusionary rule. Now, this is a common law concept. So this is not in the statutory law. This wasn't passed by Congress. This came from the courts. And we first saw the exclusionary rule in 1914. The court had a federal case, of course, and they were talking about the fact that if law enforcement does not go through the proper procedure to obtain evidence, then they're not going to let you use that evidence against a person at trial. I think that the police had, I can't remember what they had done to Mr. Weeks, but, and they also said this part, the fruit of the poisonous tree. So let's just say that I am, I don't know, I am a known drug dealer. And so the police come to my house one day. They don't have a warrant. They don't have anything. And they knock on the door and nobody answers, but the door's not locked. So they just walk on in the house. They don't have a warrant. They don't have consent. No exceptions. They walk in the house. They're walking around. They're looking. They really don't see anything. One of the officers opens a drawer. And in the drawer, there is a key. And it has the name of a facility on it. Storage facility on it. And a number. So they go to the storage facility, open it up, and they find in there just kilos and kilos of cocaine. Just front to back. And in the back, there is a body. A dead body. For somebody that they have been looking for quite some time. And this person was a rival drug dealer of mine. They know that. So it is quite obvious that I have done something and I have in my control at least felony level amount of cocaine. It is very suspicious, to say the least, that I have a body in the storage facility, which only I had access to. So, even though it is quite obvious, they still cannot use any of that evidence against me, because the only way that they made their way to that facility and gained access to it was because they did not follow procedure. They did something that was in violation of the law. So if it is illegally seized evidence, you can't use that evidence. You also cannot use any evidence that you wouldn't have gotten any other way. If we look at it in real terms, the exclusionary rule keeps police officers from skirting the law and then taking advantage of it. So this was a well-known and oft-applied doctrine in law enforcement and in courts, in federal courts. So, in the late 50s, there was a case in Ohio, a lady named Dollree Mapp. And they say Dolly, but her Dollree was Dollree's name. Dollree was known to the police. She had lots of professions. She was a hustler. She just did many things, and had lots of friends that were involved in criminal enterprise. So there had been a bombing in the city, and the police had gotten a tip that the suspect was at Dalry's house. So they go to her house and actually knocked on the door. And I've heard the story so many different ways, but they asked her if they could come in. She told them to hold on, and she actually called her attorney. And her attorney told her, they're standing outside waiting. Her attorney told her, you do not let them in without a warrant. The Madeline rule. They don't have a warrant, you're not consenting. So the police, after having stood out there all that time, said, oh, we have a warrant. And they flashed around some paper. And so Miss Mapp let them in. They did not find the person that they were looking for. They did not have actual consent. They had deceived her, and they did not have a warrant. Now, while they were searching the house, they found some contraband. One of the things that Miss Mapp did was sold porn, and they found that. They found some drug paraphernalia as well, and they charged her with possession of the lewd material and with possession of drug paraphernalia. She ended up being convicted on the lewd material only. So, notice the year. This is right in the middle of the Warren years. As I told you, criminal defense attorneys were appealing right and left. This one was before Miranda. So, which was heard in 1966. In 1961, the case makes it to the Supreme Court, and the Supreme Court applied and incorporated not one of the amendments, but the common law concept of exclusionary rule that came from Weeks. As far as the Warren Court was concerned, they were writing law. They were writing law. So, at this point, they overturned Miss Mapp's conviction, incorporated the exclusionary rule for all states, and said from now on, if you have obtained material in violation of the Fourth Amendment, whether you're a local law enforcement, state law enforcement, and certainly federal, it's been that way since 1914, you cannot use that evidence against the defendant in court. You're going to have to find something else, but you cannot use that evidence against them in court. Couple of exceptions to the exclusionary rule. One of them is good faith exception. So just, say that a police officer had written down a particular address, and when it got printed up, the address on the affidavit, the address on the warrant was different than the address that the officer had requested. So they go to the house that they thought that they had the warrant for, except for a typographical error, and they execute the warrant. So there is a mistake, but that mistake was not the officer's, and so they won't hold that against an officer if there's a technicality. and the officer really believed that they had the authorization to do it. Another exception to the exclusionary rule is the inevitable discovery exception. So if they would have found it anyway, then like in my example, eventually somebody was going to smell something, and so maybe they're able to do something with that because it was going to be found. There's also a plain view exception to the exclusionary rule. So you have not done any bad police work, it was right out in the open. So that is another exception.